Morning and welcome to another episode of Law and Order, the program where we discuss legal matters. On today's episode, we are going to discuss about directors' duties, and to do so, we have with us Vikum Jayasinghe, attorney at law. Good morning and welcome to the program.
Good morning, Prashant. It's a pleasure to be here this morning.
Okay, now to start off, I'd like to ask you, what exactly is the role of the director?
So in terms of getting into the role of the director, if I give you a bit of background, let's assume that you yourself would own a boutique shop maybe somewhere in your neighborhood. You might employ a few people to run the shop to help you out with a few day-to-day activities, right? But at the end of the day, you know that you are in control. Maybe you might be the only person who have access to the cash register, and you know everything that is going on in and around your business. So in that particular situation, you would not see the need or the requirement to have a separate person, an independent person coming in to help you manage your company. Mm-hmm. However, if we assume that along the line you develop this company, it grows, and you maybe shift it to a much bigger place in the town or in the city, you might end up having a few more shops open, and in that particular situation you might feel that, okay, I can't be here 24/7, I don't really have the entire control over all of these outlets that I do have. So in that particular situation, you might consider the requirement or the need to have a person, an independent individual coming in to help you manage your company. Uh-huh. Also, it happens in a situation where when you shift from your normal ordinary boutique shop to a company incorporated, which basically means that it's a separate legal entity. If I just elaborate on the importance or the difference between a company which you incorporated versus you running your own shop, which is a basic sole tradership, what we call, is primarily based on the limited liability concept. Because you see, now if you were running your own shop, and let's say particularly at times like this, between hardships like this, you would want to borrow some money, and you end up not being able to pay this money, your liquidators would pile up, your creditors would pile up, and you might not be able to sort of settle these creditors. Mm-hmm. In that situation, you realize that the money that you have invested in the company or in your boutique shop in that particular example is actually not sufficient, and you might have to put some money out of your own pocket to settle these creditors, which you will have to do in a situation of your ordinary boutique shop. Mm-hmm. However, if you do going to incorporate this particular entity as a registered company in Sri Lanka, there is a limit on your liability. There's a limit on the amount that you are liable to the outside parties. So therefore, in that particular situation, your liability will only be limited to the amount that you invested on your company, and the creditors would not be able to come behind you and ask that you give that money back from your own pocket.
Right.
So that is your basic definition or distinction between a company and your sole tradership. And in terms of converting your sole tradership into a company, that is where this crucial individual called the director comes into place, who would help you manage your company to the best of his or her ability.
Now, what's the importance of imposing these duties on a director?
So, in terms of the importance of imposing these duties, you see examples from all over the world in terms of situations where directors were directly responsible for the mismanagement of companies. For example, you would start with something like the Enron scandal, which all of us, even though we are in the small island of Sri Lanka, all of us are aware of it. And you see that after scandals like Enron, then WorldCom, etc., you saw certain legislations coming into place, like, for example, the Sarbanes-Oxley Act in the US. So those legislations made it ensured that directors are given specific responsibility, that they are accountable for their actions, so that situations like that would not happen in the future. You see situations like that which happened in the past in Sri Lanka also, in respect of certain investment and finance companies as well, where directors were actually in fault in terms of the bad management and in terms of not being accountable. So that is why one would consider it is very important to make sure that there are strict rules and regulations in place for the directors of companies, so that they would in turn make sure that they act in the best interest of the company, so that all the parties involved, all the interests of the parties involved are in fact safeguarded.
Right. Now, let's also touch on conflicts of interest. Tell me a bit about this as well.
Okay. So now, like I said before, you would obviously assume that a director appointed by you to your company, his main obligation is maybe to act in the best interest of your interests, right? If I take a different example, let's take the representative democracy system that we have in Sri Lanka, right? So then you understand that you and I are both sovereign and we have the sovereign power. However, since all of us cannot get together in governing this country, what we do is we vote and we elect representatives who would go into the parliament and act in our benefit most probably. But also that mandate in terms of representing us includes a responsibility not only or above and beyond the obligation to act in our benefit, the obligation to act in the benefit of the country as a whole. And that is where you need to understand in terms of directors of companies as well, that even though you as an owner or shareholder might end up appointing them at a general meeting, the obligation of directors mainly and primarily is for the sake of the company. Their obligation is to make sure that the company's interests are safeguarded. So in that situation, there might be a certain conflict where they would maybe they might have to take a certain decision where they would feel what would be best for the company versus what would be best for the shareholder who appointed me. That is where the conflict arises. So the director might have to think that, okay, if I take this particular decision, this might end up giving a higher dividend to the shareholder, and the shareholder who appointed me would in turn be happy, and he might even extend my term for the next year. However, the obligation or the primary obligation of the director would be not to firstly think about how I can please my shareholder, but more or less to think about the interests of the company. So therefore, the director might be better in deciding that no, without maybe deciding on this particular dividend, I will decide to reinvest this money in the company so that the company can perform well, so that the company can grow. So in such situations, you feel that there is in fact a conflict of interest, but the primary obligation on the director would be to act in the benefit or the best interest of the company. And you see specific provisions in the Sri Lankan Companies Act, if I remember correctly, section 187, specifically imposing these obligations where the director is supposed to act in good faith in the interest of the company.
Right. Now, in a practical sense, what do you think happens the majority of the time? Do directors really move towards the company's interests, or do they cater to the shareholder who appointed them? How does it usually work?
Yeah, so you would see a lot of situations where companies end up in newspapers is where the directors would primarily act on their own benefit. They would try to smuggle money out of the company. They might make sure that they give certain transactions or deals to interested parties without properly vetting these transactions. So you see a lot of situations where companies, where you find cases coming into the commercial high court, you see the directors either acting for their personal benefit or mismanaging the company in general. But of course, to answer your question, you would feel that in reality what happens is the director would always have in the back of their minds that, being human, that they have an obligation towards the people who have appointed them. But in principle, the reason that you would bring these people in to run your company is to make sure that your company succeeds at the end of the day, and to look at the broader picture stemming from my previous example. If the director thinks that if I do what is best for the company, at the end of the day, you as a shareholder would also benefit out of that decision. So that is why it's important to make sure that you act in the best interest of the company. And also, the only stakeholders in this particular situation is not only the company versus the shareholders. You have to consider the interests of your employees, you have to consider the interests of your state, of the country as a whole, maybe in terms of your making sure that you pay your taxes on time, making sure that you don't harm the environment. So there are a lot of stakeholders coming into this whole transaction. But I feel if you focus on the interests of the company genuinely, all the other interests of the shareholders and stakeholders are also at the end of the day, in a broader manner, is being satisfied or is being fulfilled.
Right. So directors really have a moral obligation when it comes to carrying out their duties.
Indeed. You don't really see the moral obligation put on black and white in our statute. However, it's very correct that you phrased it in that way. A director certainly would have that particular moral obligation.
Right. Now, when it comes to all these duties that are imposed on directors, what are some of the common duties among directors?
So if you again look at the statute, you would obviously have a specific duty in terms of to act in the best interest of the company. However, going beyond that, you would also have specific obligations being imposed by the statutes in terms of to make sure that you follow the act, and you act as in the Companies Act, and also to make sure that you follow and you're obligated to follow the articles of association in a company. If I just explain that particular concept to you, that might be similar to the Sri Lankan Constitution, for example, stemming from my previous example. So even though you appoint a representative to the parliament to make sure that the country's interests are being safeguarded, that particular individual must also act in accordance with the Sri Lankan Constitution. And the constitution for a company is the Articles of Association. So a director has a direct obligation to make sure that they comply with the Articles of Association. Also, there are other certain responsibilities that is imposed on directors in terms of maintaining that the company runs successfully, that you don't mismanage the company, that you make sure that the company is solvent, passes the solvency test in terms of specific transactions that you get into, that you disclose particular interests that you might have in certain transactions, and also a general duty to act in the best of your ability. So you would see that a reasonable person acting in the best of their capacity, you would have that obligation also being imposed on a director to act to the best of your capacity. It doesn't necessarily have to be to have a certain expertise in a certain field, but a general duty to act, to do your best, basically.
Right. So out of all of these, what are some of the key duties of a director?
In terms of key duties, I would also feel that at the end of the day, what you need to specifically look into is to make sure that you look after the company, because that is what you're appointed there to, right? And in terms of looking at the duties of directors, you might also need to consider what sort of a director you are, right? So the Companies Act doesn't necessarily distinguish particular types of directors, but other regulations and how businesses are being governed, you see a practical distinction, very especially in terms of, for example, your executive directors versus your non-executive directors. So you would see that the obligations imposed on your executive directors might be slightly higher in terms of they get involved in the day-to-day management of the company. So they play a much more involved or much more key role in making sure that the company is managed well. Versus you would use your non-executive directors to make sure that the accountability is there, and to make sure that the other directors also are fulfilling their obligations. So then you consider some of the corporate governance requirements, which would maybe tell you to have a certain amount of non-executive directors in your company, or those requirements might say that certain committees like the remuneration committee, which decides on the remuneration of the directors, those committees will primarily have to be headed by non-executive directors. Maybe audit committees, which audits the financial position and the financial statement of the companies, so those committees might also again have to be spearheaded by non-executive directors. So this distinction in terms of what role you play as a director also affects your responsibilities that are being imposed on you.
Okay, and just as a clarification to our viewers, when we take the terms the board of directors versus the managing director, how would you, in a legal standpoint, distinguish the difference in their responsibilities and what they have to offer?
Okay, so in terms of the distinction between an ordinary director who is a part of the board of directors and the managing director, or you might also call that particular person the CEO.
Correct.
You might consider the managing director or the CEO to be the person running the company, who is the head of the company. However, you would have that particular individual as well as other directors who supports him in running the company, and that would compromise the board of directors, and you might end up having a chairman who would head that particular board of directors, who might be different from the managing director. So the chairman would make sure that the board of directors act according to their responsibilities and capacities, versus the managing director would make sure specifically that the company is being managed well. And in terms of this distinction, it's important to consider how the Sri Lankan Companies Act also defines the director, right? Because it's not only where you would be called on paper a director. The Companies Act defines it in a very broad sense to say that even though you are a person who is, let's say for example, calling the shots from behind the screen, you have a puppet basically appointed as a director, but it is in fact you who is managing the company from behind the scenes, and you are the person who makes sure that this particular individual who is for the namesake appointed as a director does your bidding basically. In that particular situation, the Companies Act actually recognizes you also, even though you're not termed a director, you also falls within that broad definition or classification as a director, and therefore you have those same responsibilities and obligations that would fall on any other director as well.
Okay. Now, what happens when there is a breach of duties when it comes to a director?
Okay. So, in terms of a director breaching their particular duties, now it can be, the consequences of it can actually be massive, because of course you can understand the general consequences of. The most probable consequence would be the company failing in its business, the company not being able to carry out its business, right? And that of course will in turn have a ripple effect in terms of its employees, and maybe at the end of the day might have an impact on the economy of the country as well. But if you consider it in a much more broader sense, if I for example take a bit of a dire example, let's say you are a director in a board of companies where, and under your group you have a nuclear power plant. You all manage a nuclear power plant, and you are a director of that power plant. So in that particular situation, let's say one of your senior employees would come to you and say, for example, there's an issue there with one of the machinery or whatever, which needs to be fixed or which needs to be repaired. However, to do that particular fixing, you will have to shut down the power plant for a few days. That might seriously affect your income, that might seriously affect the transactions that you have with the state or with other private entities. So then you need to make a decision whether we will risk running the power plant for a few more months or weeks, so that we might be able to find a time period where we can look into this particular issue, or whether you make a decision to shut down the plant now itself and make sure that this particular machine is fixed. So let's say you assume that you make that decision, oh, we are going to continue, and something catastrophic happens, then you're responsible to millions, it could be even thousands or millions of lives, So the consequences of directors not being responsible or not fulfilling their obligations are not really limited to the company going bust or the company failing, but you will have much more dire consequences in terms of massive environmental harm. I'm sure you would remember a lot of these companies who got involved in a lot of environmental issues. I wouldn't specify names, but a lot of environmental issues in the past, right? And you have companies where, as a result, you have certain motor car companies where, as a result of the directors' negligence or decisions to not fix certain issues, which caused losses of lives. So you need to really understand the gravity of directors' duties in terms of the obligation that they have and the need or the requirement that they fulfill these obligations, because it could end up having very catastrophic results.
Right. Now, coming back to the topic of conflicts of interests, we discussed what would happen if a director was to think about his or her own interest and thinking about the company's interests. Let's talk about what would happen if there's a conflict of interest within the group of directors. Like you mentioned, a very practical scenario can be environmental harm or a nuclear power plant. When it comes to situations like that, what if the majority is saying we go ahead, whilst one or two, the minority is saying no, let's cut back? What happens then?
So in that particular situation, when you do have a conflict in the board of directors itself, so assuming that this conflict stems from one particular individual director's interest, let's say, for example, that particular director might have an interest in a particular transaction. So your company is planning on going into or planning on expanding, and you want to give a particular contract to a separate company, but this director has an interest in this company, whereas assuming maybe a relation of a director owns that company. In that particular situation, if a conflict like that occurs, you need to firstly obviously disclose it, and you need to take yourself out of the equation. You shouldn't be involved in that particular decision making process. You need to disclose it, but that doesn't mean, let's say, that particular option might be the best option for the company as well, even though you have an interest in it. So that is why the company law regime doesn't prevent you from going ahead with that transaction, but what it says is you need to disclose it, then you need to take yourself out of the equation, so that the rest of the board, who is independent, who doesn't have an interest in this particular issue, then they can of course get together and take the decision that is going to be beneficial for the entire company as a whole. Also, in other situations where you do see a particular conflict of interest happening, then maybe the chairman comes into play. The chairman would have the upper hand in terms of deciding, okay, this is what we are going to do, this is how we are going to go ahead. But in a general sense, all the decision making of the board will happen on ordinary resolutions, which would say this, a majority of the board agreeing on a certain aspect, and they would go ahead with it. But if you feel that, if you find a situation where the board is unable to agree on a certain aspect, then of course you would rely on the chairman's position to make that decision for the sake of the board and on behalf of them.
All right, okay. Thank you so much. That was Vikum Jaisinghe, attorney at law. We discussed a lot about the role of a director. Thank you so much for all that information and being on the program today.
Thank you very much, and I thank Law and Order for the invitation extended to me. Thank you.
And that winds up today's episode of Law and Order. Do join us next week as well. Till then, have a great day.